will not show up on this video, but just know that that will be distributed after. So we're excited to have a workshop here today. I just wanted to go over a couple of notes related to Zoom for those of you who have or have not used Zoom webinars before. They're a little bit different than meetings. We do have the chat option, which is sort of similar to the meetings, but please note that it tends to default to just sending messages to panelists. So if you want to send out to others, make sure you have checked for the attendees. We also do have a Q&A section that you should be able to find, again, in the bottom bar of your Zoom control screen. And that's a great spot to please put any questions you actually have. Amanda's going to be doing a wonderful presentation, and we'll basically be holding most questions to the end. But feel free to put them in there whenever they come to you. You should also potentially be able to comment on questions. So if you have a sort of a question that follows up on somebody's question that's already there, please feel free to do that. And then we do have the raise hand feature. So again, if you've got any direct questions or want to make a comment after we get through the presentation part, we appreciate you using the raise hand question. Everybody who is an attendee is automatically muted, and we will have to unmute you. So that's sort of another little difference as well. So that's why the raise hand feature is fantastic. So I am going to now turn it over to Darlene, who is the president of the Collections Care and Conservation Alliance, to talk a little bit more about that and what brings us here today.
Excellent. Thank you, Eileen. Good afternoon, everyone, and thank you for joining us for the Collections Care and Conservation Alliance first educational program of 2021. We're thrilled that so many of you are able to join us and that registered for the event from so many different places across the country, including the world, Egypt and Canada. If our colleagues are here from those two areas, welcome. We're glad that you were able to join us. And as Eileen said, my name is Darlene Bileski, and I am the president of the Collections Care and Conservation Alliance, or as CCCA, as we commonly refer to it. We have developed a series of virtual workshops for this year, and we'll be slowly releasing their topics along with the details as they're confirmed. So be sure to subscribe to our mailing list if you have not done so already. You can find the subscribe button at the bottom of each page of the website. We also look forward to being able to meet and gather in person again when that's all safe, and we'll be certainly providing some opportunities to get together as we get closer to that period in time. If you are a new member of the Alliance, welcome. If you are not yet a member, please visit our website. You'll see that I've put the URL in the chat box, and consider joining us. There are 3 levels of membership: professional, affiliate, emerging professional, and student. And each has its own set of criteria for application. For 2021, the latter 2 levels, emerging professional and student, have their membership dues waived for this year. Benefits for these levels include a member-only invitation to what we call conversations with colleagues. This year, those conversations will follow the workshops that we are providing, and we'll continue the discussion at that time. And as I said, these conversations are generally member only, but for this workshop, we're inviting anyone who registered for the event to join us, even though they may not be a member yet, sort of to test the waters and see what you're missing. We also have a category called Friends for those who do not fit into the 3 membership levels, but wish to support the mission of the organization and participate in educational programming. For today, as Eileen has said, the chat box is available for comments, and please put any of your questions in the Q&A so that we can be sure to not miss anybody. And if there's a chance we have lingering questions that were not yet answered, Amanda has agreed to answer them afterwards, and then we will circulate those responses. Also, as Eileen had mentioned, we will have the Q&A following the presentation. With your registration for today's event, you will receive a link to the recording so you can view it again if you so choose. And following today's presentation, you'll receive a quick survey that we would appreciate very much that you complete so that we can improve our programming or add to as you see that we need to. Today's webinar is a topic that is complex, challenging, and one which anyone who deals with collections should have a basic understanding of. Our speaker today is Amanda Nelson, Esquire. Amanda spent more than 15 years as a museum curator and consultant with a specialty in collections care and management before attending law school. Her practice focuses on the legal needs of the artistic community, including individual artists and artist organizations, both for profit and nonprofit. Amanda's education includes a BA in history and an MA in history and museum studies. She received her JD from the University of New Hampshire's Franklin Pierce School of Law with a focus on art and museum law. She's a board member and president of the Weeks Brick House in Greenland, New Hampshire, a board member of the Woodman Museum in Dover, New Hampshire, a board member of Red Arch Cultural Heritage Law and Policy Research, the board on which I also sit, and that's how I know Amanda, and a member of the Dover Arts Commission. So without further ado, Amanda, the floor is all yours.
Thank you, Darlene. Now, I did see that a link in the chat was put up to the materials for today. Basically, I took the PowerPoint that I put together and created an outline, so you'll have the materials at hand because I don't want anyone feeling like they have to scramble to take notes. And it really is more important that you have a chance to kind of sit back and digest some of the information that I'm giving here, because as Darlene pointed out, it's an incredibly complex area of law. And I can't see everyone, but in the past, when I do this presentation in person, there's always a point in this presentation where I could start seeing heads spin because of the complexity of the materials. So again, at the end, there will be a question session. So please feel free to ask your questions. And I actually am going to share my screen now, and hopefully it'll let me do that. And let's see. Excellent. All right. Hopefully everyone can see that. Darlene, Eileen, excellent. Okay, good. So today we're going to talk about the basics of United States copyright law. And as Darlene said, this is an area that is really important if you have any kind of collections that you are a steward of, because obviously you want to be able to use those items, reproduce those items, share those items with the public. And it's really important to know when can you do this, when can you not, and how do you determine when something actually goes into the public domain. And one of the quotes that I absolutely love, and this is Mark Twain, and he actually is quoted as saying that there's only one thing that is impossible for God: to find any sense in any copyright law on the planet. And I think he sums it up beautifully. And that's 19th century, he's saying this. And it's only gotten more complex as time has gone by. So what are we going to talk about today? Believe it or not, we're actually going to talk about two distinct copyright laws in the United States: the 1909 Copyright Act and the 1976 Copyright Act. How do you get federal protection under the two? Under the two, how long did copyright protection last? How did a work enter the public domain, and when did it enter the public domain? And of critical importance for many of you that are a nonprofit organization, when is it considered fair use of a work that you don't necessarily have to seek permission of the copyright owner to use that work? So that's sort of the big picture outline of where we're going to go today. So why do we need to know both? The Copyright Act was completely overhauled in the United States in 1976, but it was not retroactive. Therefore, anything published before January 1st, 1978 is covered by the 1909 rules. Now you say, wait a minute, how come if it's the Copyright Act of 76, why are we worried about January 1st, 1978? Well, Congress realized that because this was such a massive overhaul of the existing act, they wanted to give people 2 years to get used to the new rules and to understand what they meant. So that's why it's the 76 Act, because it was passed in 76, but it didn't take effect until 78. Again, the prior one was 1909, and it had very, very different rules. The 76 Act came about because the 1909 Act was so unfair to artists. Artists lost their copyrights without even realizing it. They would put something out like in an exhibit or publish it, and they, without following the rules that they didn't even know about, it automatically went into the public domain. And there was a point where Congress was realizing this was really unfair for people who were creating these works who didn't understand the law and were automatically losing the rights to their works without realizing it. Now, for the vast majority of people, the 1909 Act doesn't matter. But why does it matter for our profession? Because our collections often have multiple works in them that date before January 1st of 1978. And that's why for our profession, first and foremost, we have to understand that we're dealing with two distinct copyright acts. Brief overview of intellectual property. This is what copyright is. It's part of intellectual property. And people confuse the terms all the time. So I'm just going to give you a really brief overview so you can understand the terminology behind this. And don't be afraid to ask questions about this, because I know lawyers who don't even understand the difference between these various areas, and they misuse the terms all the time. So when we talk about patents, we're talking about science and engineering, about the fight between Apple and Samsung over the microchips in their cell phones. We're talking about the formulation of drugs and the pharmaceuticals. This protects the formulation, the process, and that sort of thing. Museums don't tend to deal with patents. So that's why I don't really go into this very much, but you should at least be aware when you hear this term patents, that's what they're talking about. Trademarks, however, yes, you'll most definitely be dealing with trademarks in your organization. And what is a trademark? It's a simple way of creating an identity that as people are driving down the road and they see your sign, they know exactly who you are. And it's designed to prevent customer confusion. In the marketing world, this is called branding. So you can see some of these trademarks, and for example, MoMA, you don't even necessarily have to think about that if you know about the Museum of Modern Art. You know that's their logo. And these are some of the logos from various museums across the country. As I was looking at museum logos, I had no idea there was a Museum of the American Cocktail. I just thought that was hilarious. And yet they have a wonderful little logo. So this is your identity. And many of you are going to have that, either a logo or a name or combination thereof, that identifies who you are as an organization. But today we're going to talk about the juicy stuff, copyright. What is copyright? Fun fact, copyright's actually protected by the US Constitution. It is in Article 1, Clause 8, Section 8, for those of you who want to look it up for whatever reason. It basically says that for a period of time, authors and inventors have the exclusive right to their writings and discoveries. If you talk to copyright lawyers, this is the copyright clause. If you talk to patent lawyers, i.e. inventors and discoveries, this is the patent clause. But basically it confers an exclusive right, a monopoly to use your creation in whatever way you see fit. How do you get a copyright? Well, first of all, the work has to be original. And the courts have made it very clear that originality, you don't need much. It's a very, very, very low bar. Here's the thing though, it has to be in some sort of what they call a tangible medium of expression. Well, what does that mean? In other words, you can't just have an idea in your head. That cannot get copyright protection. You have to put it down on a piece of paper. You have to record it into your cell phone as a recording, because it has to be able to be reproduced. One of my professor's favorite things she used to say was that you're in a restaurant, you come up with an idea and you scribble it on a cocktail napkin. That is copyrightable because you've got an original idea on a tangible medium of expression. That cocktail napkin can be reproduced. So again, ideas are not just good enough. And you often see people come up saying, that person stole my idea. Well, did you write it down anywhere? Well, no. Sorry, there's no copyright there. You have to be able to reproduce it. And we can't do that with ideas unless they're expressed in some manner. That's the important other thing to think about copyright is it protects the expression of the idea, not the idea, which is why you can see variations on a theme, because as long as the details and the expression of that theme are different, then each can have its own copyright. I think about after Harry Potter became incredibly popular, and then all of a sudden you saw variations on stories of wizards going to schools. And each of those were perfectly capable and copyrighted as long as the expression was completely different in terms of that. So that's the substance of copyright right there. So when we talk about copyright, they are actually rights. These are rights that people have. We call them intangible rights because they're not really anything you can hold on to. It's not like the ownership of the book itself, which is a tangible property right, because you can actually hold that book. You can hand it off to someone else. You can rip it apart. You could color in it. You could do whatever with it. These are intangible rights because how do you hand off literally the right to reproduce? You can't. There's no physical thing to hand off. So these are rights. You have the right to reproduce, i.e. copyright. And sometimes it's interesting, people spell it COPYWRITE because they are thinking writing, and that's not correct. It's copyright because it's the right to copy. The right to distribute that work, the right to make derivative works of your work. So back to the example of Harry Potter, you had Harry Potter, the books. The derivative work of that would be the movies because you're taking something and you're turning it into something else. And books and movies are a great example of that. The right to public display, very important for all your institutions, and the right to public performance. These are 5 separate rights, and each one can be divvied up to different people. You can take your copyright and give one person the right to reproduce it, but they can't make derivative works. You can give someone else the right to distribute it, but they can't make derivative works. Or maybe they can distribute it, but they can't reproduce it. All of these can be broken up into separate rights. So when you are looking to obtain the rights to a collection that's being donated, you want to make sure that you're taking into account all of these rights and not necessarily being limited in terms of what you can and cannot do. So what can be copyrighted? We already talked about this. The list is just mind-boggling. It's how extensive that list is. And this is why I bring this up, is because you really need to be thinking about all the varieties of things that could be copyrighted. So photography, that one's a pretty straightforward one. Architectural plans can be copyrighted. The architecture itself can be copyrighted. And that's a fairly new right. So for example, this building, if you were to go out and make an exact replica of this building, it could be copyrighted and you could be in trouble for that. Obviously, any kind of public art, statuary, 3D art, maps, as long as they have a creative, original element to them. And I think a lot of cities make maps that look like this one from Montreal because it allows the city of Montreal to now copyright their map and nobody else can copy it. Facts cannot be copyrighted, okay? If this were a map that was literally showing streets and the geographical layout, it would be very hard to copyright. But you make it pretty with interesting designs and it's not quite to scale. Now you suddenly got something you can copyright. Television, cartoons. I like this one because it's actually a combination of both trademark and copyright. The scripts to these things, the characters themselves can be copyrighted. You may have seen in the news, there's been a lot of talk recently about Sherlock Holmes, because some of the Sherlock Holmes stories have fallen into the public domain. There's one or two that are still lingering, that are still protected by copyright. And between the Doyle estate and people who are wanting to use the character of Sherlock Holmes, and whether or not they can actually do that. They've only got a couple more years though. Books, literature, obviously, can be copyrighted. Music. And here's the thing with music. It's got 2 copyrights to it. Very, very important to remember. The underlying composition and the public performance of that composition. One of the things I see really often too, and I've been guilty of this before I knew any better, is you'd have an event and you have I'm dating myself, a CD, that's terrible, of music. And you think it's perfect, right? It's Mozart. That's in the public domain. Well, yes, the underlying composition of Mozart is in the public domain. But if that public performance that's on that CD or digital file or MP3 or whatever it is we're doing now was done and recorded by the Boston Pops in 2015, you're in trouble because that recording is protected by copyright. So when you're doing events, think about that. You know, it's not just the composition itself, it's the performance of that composition. Film, let's just say there's a lot in that right there, a lot of copyright issues. Paintings, obviously, visual arts, dance. As long as you can notate or record the choreography, that can be protected by copyright. And very recently, up until just the last 2 years, copyright law would not actually protect the costuming of these theater performances because they said, well, that's clothing. That's considered a useful article, therefore you can't get copyright protection. Well, yes, because we all run around looking like these two on a regular basis. Supreme Court has now ruled that no, actually clothing can have a certain amount of creativity to it, expression to it, and therefore it should be protected by copyright. So this is huge for the theater people, as you can imagine. Exceptions to copyright. In this case, and this is actually explicitly put in the Copyright Act, and in our case, the idea, no protection for an idea, you've got to put it down somewhere on a piece of paper, a recording somehow. Process, system, method of operation, that's all patent stuff, and they do not like to cross lines in terms of the 3 types of intellectual property. Or concept, same thing. So in our case, copyright's really about the idea. You need to be able to express it somehow. Other exceptions, just real quickly in terms of what cannot be protected. If something is so basic and useful, it can't be expressed in any other way, like this chair. I mean, that's about as basic as you can get. That can't be copyrighted. So out on that one. To this day, and it really bugs the quilters of the world, quilting is still considered a useful article because it's a quilt. And again, they're pushing to get protection because, let's face it, that is highly creative. Pictures of nature. Many of you might be familiar with that really iconic picture of the bear catching the salmon in the river. And the gentleman tried to get copyright protection on that. And they said no, because anyone could go out and take that picture again. Now, granted, the chances of that happening again, fair enough argument, but they basically said, yeah, it's possible it could happen again. That little cute polar bear might pose in the same way for somebody else again. So they said, no copyright on pictures of nature. Pure facts. Cannot copyright facts. And that goes to a public policy of how can we have good discussions about the events of the 4th of July if no one else but one person can talk about the 4th of July. And so in this case, they said the phone book, that is pure facts. And no, just because you put it in alphabetical order, let's face it, that is the most obvious way to organize this material, this data, is to put it in alphabetical order. So again, no dice on copywriting the telephone book. Again, kind of dating myself, but you get the idea. So we're going to start off with the 1909 Act. And during this time period, there were actually two forms of copyright protection: common law, i.e. protected by your state, and federal protection. So for many states, they had on the books, and I know New Hampshire is one of them because I've seen it, protection. It protected copyright for work that was in New Hampshire that had not yet been published. Common law protected unpublished works. But as soon as the work was published, and we'll talk about what the definition of published meant, common law no longer applied. It was superseded by federal protection. And if the author did not follow the formalities that the law laid out during this time period, that work immediately entered the public domain. And you'll see as we go along why they decided to change this rule, because it was so unfair. But it's something really important, again, for us working in historic sites, historical societies, museums, to understand our own collections, what's going on with these collections. So I've been talking about these four formalities. The 1909 Act laid out 4 statutory formalities that once they published their work, if they did not follow any of them, and this is how it was number 1, and number 2, and number 3, and number 4, not a mishmash. So you had to follow all of them. And many, many artists, again, didn't know this. Not like they had the internet, they could just look this stuff up. And so a lot of times their works just immediately fell into the public domain. Now, when I talk about the public domain, and especially with the rise of the internet, this has been a source of confusion. There's a difference between public domain, which is a legal term, and public access. So just because something is up on a website does not mean for legal purposes it is now public domain. It literally means you just have access to the work. It's still protected by copyright. A lot of people say, oh, no, you put it out there, it's public domain now. No, this is a legal term of art. That means anyone can use it because it's no longer protected by copyright. So the first one they had to do was called notice, that they had to put some form of notice on the work, regardless of whether it was a photograph, a book, a painting, anything, a film. They had to include a copyright notice. Now, you're more likely to see this on books and movies than you are on paintings, and particularly photography. That one is the worst one. Photography of this era, tracking down copyright can be a nightmare because most photographers did not include a copyright notice. And the courts were very, very, very clear of what this notice had to look like. It had to have the what they call a copyright notice, what we'd call the C in the circle, the name of the author, and the date. Had to have all 3. You couldn't just put a little C on the circle, or a date, or the name. And not only that, but they're really, really particular on what constituted a proper copyright notice. So they only accepted the 3 that are here, that C in the circle, which most of us know, the COPYR dot, or the full word copyright. Any other variation on that, and they would not accept it as proper copyright notice. And there's actually case law to that point. So right off the bat, when I'm talking about how unfair this law was to authors and artists, I think you're already getting a taste of what this meant. I mean, how many of these authors and artists are going to know they were limited to these 3 and anything else was not acceptable? That's the first piece. So as a little exercise. Now, granted, this one is 2010, so it didn't really matter, but it's a good notice. Like, courts would be very happy with this notice because it's got the symbol, the date, and the name of the author, or the artist in this case. Compare it to this one. No good. No copyright notice, no date. So the minute this painting would have been made available to the public, and we'll talk about what that means, it would have gone into the public domain. I understand Van Gogh predates a lot of this, but it's a good example of what this would look like. So if you've got paintings in your collection that go from 1909 up, you can look at some of these and say, ooh, look, they did not put the proper notice on it. That is very, very common for paintings. Why? Because the artist didn't want to muck up their painting with copyright notices and that sort of thing. So this is considered a bad notice. Watch out though for the ambiguous ones. Make sure you're reading it properly, because your initial instinct might be, oh, well, this is a copyright notice, right? Well, no, actually it's not, because if you know your artists, Pissarro's first name was in French, Camille, or in English, Camille. So no, this is not a proper copyright notice. Publication, I've been using this word a lot. They strictly have defined what notice means. They are wishy-washy when it comes to publication. Generally, they have said publication occurs when the work is made available to the public for them to use the work as they see fit. Now, what does that mean? So merely hanging a painting in your gallery is not good enough. That would not have been copyright. It would not have been in the public domain. However, back in the day, if your museum made a gallery catalog and it featured these works and then handed out that catalog to the public, that's considered a publication, because now you've made the work available to the public, and now they can take that catalog and they can do whatever they want with it. If that catalog did not contain a copyright notice, and I've looked at a lot of these very old catalogs and most of them did not contain a copyright notice, you put the work into the public domain with the distribution of that catalog. So again, I mentioned putting it on display does not necessarily mean publication, but here's the other piece. A lot of galleries and museums encourage people to come in and sketch out the work, make copies of the work, draw the work. You know, I've frequently walked through various museums and you see the art student with their sketchbook copying something. If they allowed the organization to copy the work, it's been published. So, and now of course, this is where heads start spinning, because you're saying, well, I have no idea what my organization was doing in 1930. Fair enough. That's a very fair observation, which is why this makes it really, really hard to figure some of this stuff out. But these are the two pieces: notice, and publication. Right off the bat, I've seen so many works just fail even that basic level. The next one is, say they've done everything right. They've got the proper copyright notice and they've not allowed the public to copy it. It's not been published in the traditional sense. The next step is, before you publish it, you had to register it with the Copyright Office. Copyright Office is in DC, still there. Registration used to be paper-based. Now it's mostly done online, and really, actually with COVID, it's really now being pushed online. The registration creates an official record of your copyright. I've included a link at the end of this presentation to the Copyright Office, so you can take a look at their website. Their website is actually generally very user-friendly, and you can look up various records from 1976 on. They've not yet digitized records from before 1976, so that makes it a little bit more difficult. I know they're working on it, but they only have so many people and so forth and so on. Like any government agency, they are understaffed. So registration created an official record of your copyright. Nowadays, you're technically not required to register your work, but the Supreme Court actually ruled in 1909 that if you wanted to take advantage of modern statutory protections, which we're going to discuss a little later on, you now have to register your work. So we've kind of backtracked a little bit to more of the 1909 kind of ideas, but you had to register your copyright. And on top of that, you had to send them 2 copies of your work. And that is still the case today. If you were to register your work, you still have to send them 2 copies, although they're increasingly pushing that you don't have to send them 2 physical copies. Digital copies are perfectly okay. And they kind of prefer that because they only have so much space that they can keep things. So one was retained by the Copyright Office and the other was sent to the Library of Congress, which is why there was 2. So those are your 4 formalities: the notice, the publication, registration with the Copyright Office, and deposit. So because these records are not online yet, you're going to ask, well, how do I know if say the copyright notice is good, say they did everything right with publication, that as far as I can tell, how do I know if they registered it, if these these registrations are not available online in their database? We'll get to that. Quick side note, and we'll talk about this: work made for hire. Some of your organizations may have commissioned work from an artist. Not unusual. So how do you know when you commissioned that work who has the copyright? Under the 1909 Act, the copyright followed the commissioning work. This goes to donations of your collection. If you were donated a work or a collection before 1978, remember that date, the copyright followed, unless there was a written agreement stating otherwise. And that's the same thing with a work made for hire. The work commissioned, the copyright followed the work, i.e. the one who commissioned it. This is completely the reverse today. That's why that date is so really important. So how do I know if it was registered under the 1909 Act? Well, you can ask the Copyright Office to do a search of his records. That's going to cost you money. You can send someone down to the Copyright Office when they're open again to the public to do the research. But again, that will cost money unless you actually have people in DC who can just pop over there. The best thing you can do, and those are the 2 if you want to be absolutely sure about something. But the next closest thing you can possibly do is research this thing called the Catalog of Copyright Entries. What is this? Well, back in the days before internet and online databases, the Copyright Office would issue updates every year of works that had been registered with their office. Very handy. And these have been digitized. So this is just one example. It's works of art, and they do break them up. So they'll break up works of art, they'll have literature, they'll have other areas. So you can really kind of narrow down. And this is basically what it looks like. It's just a listing of everything that's been registered with the Copyright Office. These have been digitized. And I've got the web link, the website link at the end of the presentation. Is it perfect? No. But without having to spend a fortune to do your research at the Copyright Office, it's going to be the closest thing possible for you to be able to determine whether or not something has been registered with the Copyright Office. In the type of copyright registration or copyright research I've done for older collections, very rarely have I ever gotten to this step, because 9 times out of 10, either there was no notice or was published, and they never took notice. Actually was the big one. 9 times out of 10 there was no notice, so that was right off the bat that went into the public domain. And then there was a question of the publication, and 9 times out of 10 they never bothered to register it with the Copyright Office. That's the 1909 Act. Now we're going to talk about the 76 Act. And again, don't let that name fool you. It did not go into effect until 78. And again, that was in order to allow people to make the switch and adapt because it was so different. It got rid of common law copyright protection. It was no longer available. It basically said copyright protection exists at the time you create your work. This is the only area where it overrode the 1909 Act. That's it. So all work, regardless of its status of published or unpublished, was given federal protection, even if they were created before 1978. And I think a lot of that had to do with unpublished work because state statutes were all over the place in terms of the common law protection. I think they just figured it was easier to make a blank sweeping statement to say, you know what, we're just going to scoop everybody up who's not been published and give them copyright protection so that we don't have to parse out, you know, all these different state laws. After 1989, the Four Formalities were no longer required. This was because the United States, and I bring this up because we have international colleagues here. There's an international treaty that was created at the end of the 19th century. It's called the Berne Convention. I'm not going to quiz you on this. The Berne Convention tried to bring together a global consensus on copyright protection. And again, it started in the late 19th century because everybody was stealing from everybody. And it was actually spearheaded by Victor Hugo, who was like, enough is enough. You know, I'm tired of the English stealing my work and everybody else stealing my work. Let's all get together and try to get some consensus as to what constitutes copyright law, and we'll all agree to put this together. And since we have international colleagues, Canada joined the Berne Convention in 1928 and Egypt in 1977. So why do I have the 1989 date there? That's because when the United States finally got around to joining the Berne Convention about 100 years later. Why? In the late 19th century and early 20th century, the biggest pirators of intellectual property in the world was, in fact, the United States. Charles Dickens was shocked when he came to the United States to do a book tour and book sale. He showed up with his pile of books to his book sale, and everyone already had a copy of it because it had been pirated in the United States. If you're curious to know with some of these old books in your collection, if you have a copy of say A Tale of Two Cities and you want to know whether or not it was a pirated edition, just open up the front cover of your book. You'll see a publisher, but you won't see a copyright date. And that means it was a pirated work. It was an unauthorized copy in the United States. Lots of fun. And that might explain, if some of you have looked at those books, why there's no copyright date. It's because it was stolen. So that's the United States who joined the Berne Convention in 1989. And part of the Berne Convention said you can't have these formalities. They're not fair. People don't understand them. They don't know about them. So United States, you've got to get rid of them. That's all well and good, but we've seen a huge spike ever since in what we call orphan works. You've got a collection of photography in your archives. There's no copyright, there's no artist. Who took those photos? I have no idea, but they were taken 30 years ago. Clearly they're still protected by copyright, but who owns that copyright? And nobody knows. And the concern is, in the United States, if I use this work, is someone going to suddenly pop out of the woodwork and say, that's my work? How dare you use it? I'm going to sue you for copyright infringement. Now, there is legislation pending in Congress. It's been pending for a very, very long time. That is would basically address the orphan works problem, that it says if you follow due diligence organization in trying to locate the copyright owner, but you just can't, then go ahead and publish the work. And if the owner suddenly pops up and they can prove they're the owner, but you've done your due diligence, then they have to, in good faith, negotiate a license with you. They cannot sue you for copyright infringement. A lot of places have been saying, well, that might be the tack to use if you can't figure out who the copyright owner is, but be aware that legislation is still sitting there and it probably has about an inch of dust on it at this point because it's just not moving. And it's not helpful because the orphan works problem is just gonna continue to get worse. I had a client just yesterday, we had that issue. We couldn't figure out who the copyright owner was. Knew it was still in copyright, had no idea who the owner was. Back to the works made for hire. This is what switched, which is very interesting. It completely flipped. Under 1909, as I said, the copyright followed the work. This, unless there's a writing saying otherwise. This time this flipped, it said the copyright remains with the artist or the owner of the collection, unless there's a written agreement stating otherwise. Total 180 on this. And they defined what was a work made for hire. Employee, that's pretty straightforward. Or one of 9 specific types of work. I won't expect you to memorize them, but there they are. So for your organization, what's really important is if someone comes along and says, I want to give you my collection of this, or I want to give you this painting or this piece of art. You want in your agreement to specifically say in your deed of gift, you're giving me copyright ownership. Or if they won't give you that, get a license to be able to use it. Otherwise, you cannot use that work. And I think it was Yale found this out the hard way. They'd gotten papers from the Salinger, J.D. Salinger estate. And they wanted to do a book. One of the professors wanted to do a book on it, was quoting extensively from the Salinger papers. Well, the Salinger estate popped up and they said, yeah, we just gave you those papers. We never gave you permission to reproduce them. You don't own the copyright. We retain that. If you want to use that work, you got to work with us. And it kind of made them step back and go, oh, oops. So you want in your deed of gift to explicitly either get a license to be able to use the work or outright just get that copyright, get those copyright rights. Because under the 76 Act does not follow. It's a separate right that you have to get separate ownership of. So how long does copyright last? Another good question. There is, first of all, it runs to make life a little bit easier for all of us. The term runs to the end of year. Every single copyright, regardless of when the work was actually created, it runs to December 31st. And so every January, more works are entering the public domain. Doesn't matter whether it was May or March or whenever they created, goes to December 31st. So it makes life a little bit easier for all of us. There's no such thing as perpetual protection for an unpublished work. They enter the public domain after 120 years from date of creation. And this is one that surprised a lot of people. Guess what? It was only as of January 1st this year that we finally left the 19th century of unpublished works. And that really surprised people because, a couple of years ago, they say, yeah, but it's, Amanda, it's 2017. How can stuff from the 19th century still be protected by copyright? 120 years, that's a long period of time. So in instances of historical societies and museums, unpublished diaries, family papers or letters, those are all unpublished. So as of this year, we are finally out of the 19th century. How do you calculate when it goes into the public domain? This is when heads really start spinning. First of all, you got to figure out which act applies. Is it the 1909 Act or is it the 76 Act? In 1909, you only got 28 years and then you had to reapply and you got another 28 years. A lot of people applied for that initial 28 years and then did not apply for the succeeding 28 years. So that catalog of copyright entries that I was showing you earlier, I might find the registration for that first year And then I'd calculate out the 28 years and look 28 years later, and it had not been renewed. So it fell into the public domain. Institutional copyright was 120 years. Under the 76 Act, it was life of author, or 95 years if you're an institution. So if your institution has publications that they're putting out now, 95 years. Why is it so long? You can thank Disney for that, because they wanted to protect Mickey Mouse for as long as possible. So what I have also given you guys, and this is kind of a snapshot, but I'm going to actually get out of this and flip over to the other thing that I sent you, what I call my handy dandy copyright chart. Now, you can already see how complicated some of this is, right? But if you know your work, so it's never been published 120 years after date of creation, and as you can see, 1900. We're out of the 19th century is when it went into the, anything before 1900 is now in the public domain. The complicated stuff when it's published, and you can see published without notice, anytime between 1923 and 1927 must be published with notice in the public domain because it didn't comply with the formalities. Published 1923 to 1963, did not renew their registration. That 28-year period I was telling you about in the public domain. What if they did everything right? They did absolutely everything right. You can see now anything before 1925 is entering the public domain. The big thing for many, many years was 1923. It's now 1925 because we've surpassed the 95-year mark from 1923. And so what again, with this chart, which I found and for those of you who don't have Microsoft Excel, if you can keep it in Microsoft Excel, I highly recommend that, because here's why. And if you can figure out how to translate it to whatever program you use that's the equivalent, here's why. So if you look, I've actually created the formulas. So for each year, you hit January 1st of the year and say it's now 2022, and you look very carefully in this right-hand column, it changes the dates for you. So every year you can just change the year and you get brand new dates and you don't have to think about the math. And I don't know about the rest of you, but I like not having to think about the math. So, and now I've screwed up on my formulas. There we go. Okay, so like I said, Microsoft Excel, if you can keep it in that format, or if you can translate it to a program that works for you, you can literally January 1st, change the date, print it out, stick it to your wall on your desk, and you could easily look up the copyright dates here. All right, so I'm going to go back to my other thing. And this is just a shorthand version of what that looks like. The 76 Act also had a very interesting piece that you're going to have to keep track of, because a lot of times, and this was really a result of the recording industry, people would sign away their rights to a record label, for example, and they were vicious. I mean, they'd take everything. And then suddenly the music became so popular. So the record label was making oodles of money, and the artist who actually created the music was literally living in poverty because they had no rights to anything. So what the 76 Act did was say, if you signed away your copyright rights, then you can reclaim them after 35 years. So it gave people leverage. And we have just started seeing that in 2013, because 78 plus 35 was 2013. And some artists have very much already said, that they were going to reclaim their rights, and it has been litigated. And actually the original people to start litigating under this were the Village People. And they were able to reclaim some of their copyright rights to their songs and their performances. And what that allowed them to do was to go back to the record label and renegotiate. And it really put a lot of these record labels on notice that from the get-go, if they wanted to retain this music, they from the beginning ought to treat their artists with respect and fairness and not take advantage. Because if they were so awful and that music became really popular, after 35 years, that artist could take their work and go to someone else and totally renegotiate a whole new license. What does that mean for you? If you as an institution either commission a work or you get the rights, there is the potential that the original owner could come back after 35 years and reclaim them. I'd be kind of shocked in a museum context. I have not seen it in that context. It really has been the music industry, but I think it's worthwhile to keep an eye on the music industry to see where this ends up going. Question now, a fair use. Question on everybody's mind. When can I use a copyrighted work without seeking permission? One of the biggest issues, and I see this not only from my own practice, but I've heard other lawyers talk about this, and I've seen articles published on this. Just because you're a nonprofit does not mean it's automatically fair use. I think there's this sort of idea of we're a nonprofit, therefore anything we do is fair use. No, it is not actually. It is a factor in fair use. I'll let you know off the get-go. You've been hearing me talk about factors and this, that, and the other thing. Courts love tests, and they especially love tests that have 4 pieces to them. It's very popular. I don't know why. That's just what they love to do. So sure enough, the fair use test is in fact a 4-part test, which I will tell you about. Where does fair use kick in? It's limited. Education is a big one. That there's a component of fair use in education. This Nimmer guy, he is the guru on copyright. And just to give you a sense of how complicated copyright is, there are like at least 6 volumes, and I've seen these volumes, and these are easily like 3-4 inches thick, and it's onion skin paper. That's how complicated this area is in terms of the law. Scholarship and research is considered fair use, potentially. News reporting. So for example, in the art newspaper featured this photograph from the Titanic movie because there was an argument over the images of Picasso that was used in the movie. And when the movie went into 3D, the Picasso estate stepped forward and said, oh, no. We did not give you permission to use our paintings in a 3D manner. You can't do that, James Cameron. So there was a huge fight and renegotiation in terms of the Picasso estate in this movie. And the art newspaper reported on it. So this was considered fair use because they were doing a public service. They were reporting on this story. Commentary, criticism, and parody are another big areas of fair use. People love to comment, criticize, and parody Barbie. An artist in particular by the name of Tom Forsyth did a series of photography called Food Chain Barbie. And it was about Barbie in public discourse and the criticism of, the female form. And he always had her involved in some sort of kitchen-based appliance. So there's Barbies in a blender and there's like Barbies in a casserole dish and so forth. And again, it was the commentary of women's roles in society and so forth and so on. And as you can imagine, Mattel didn't exactly like this. And they sued, and the court basically said, no, this is fair use because it's an artistic endeavor. And he's commenting on Barbie. And we're going to actually use this case to go through the 4 factors because he pretty much, for the most part, won all 4 factors. So what are they? The purpose and character of how you are using it. Are you using it in a commercial nature, or are you using it in a nonprofit educational purpose? And this is the piece I think a lot of nonprofits get stuck on because they see nonprofit educational and then they go, oh, I'm a nonprofit and everything I do is educational, so therefore I can do whatever I want with it. No, this is 1 factor out of 4. If you are a nonprofit and you're using it in an educational purpose, yeah, that's going to lean in your favor, absolutely, but it's not the end of the story. And in the case of Food Chain Barbie, they said, yes, it is commercial. He's selling his photography, but he's also using it as a commentary, criticism, parody idea. And that goes into the nature of the copyrighted work. Did he actually literally just copy the work, i.e. did he just take Barbie and recreate Barbie, or did he do something with Barbie? Well, clearly he did, because not only did he strip Barbie down, do weird things with her hair, and put her in a toaster, yeah, he definitely did not just use Barbie and copy Barbie. This is what we call transformative. He took something and he transformed it into something new. How much did you use? And so in this case, the nature for Tom Forsyth went in his favor again. And then it was a question of how much do you use in relation to the whole of the copyrighted work. And you see a lot of stuff that people try to set up little tests, like in music, they'll say was as long as you only use so many notes, you'll be fine. No, that there's no such rule as that. Basically, it says in relation to work, did you pick out the piece that was like the most recognizable, the most important part? And in the Barbie case, they said, well, Mattel tried to argue by saying, well, he used all of Barbie. And they said, the court said, well, yes, he did. But in order to get his point across, he had to use the entire doll. Otherwise, it really would not have made much more sense. If you'd just taken the arms or something, you needed to use all of Barbie to make his point. So in this case, they ruled in his favor. Now, that's not always the case. One of the more famous cases that are out there, it was the biography of Gerald Ford. And the biography was, no, it's an autobiography. I take that back. Autobiography, that's important. Autobiography. And it was probably about 1,000 pages. And it hadn't been published, and a newspaper got in their hands on an unauthorized copy. And they reproduced exactly 900 words in the paper of the 1,000 page biography and autobiography. This is important, autobiography. And they said the reason why they said this was important, that the paper said it's only 900 words. Why are we getting charged with copyright infringement? This tome, it's 900 words. And they said, yes, you printed the part where he explained why he pardoned Nixon. Why else would people buy this book? It's Gerald Ford. The only piece they want to know is why he pardoned Nixon. You took the most important piece and you copied it. So that's why it was, they said, as a whole, this was the most important piece. So that's another thing to think about. And then the market. Is your use of that work going to affect the potential market? In the Barbie case, they said, no, sorry, Mattel, there's no way these pictures are ever going to impact your market for Barbie. It's just not going to happen. But so in Forsyth's case, he won all 4 of these. Sometimes it's a balancing act. Sometimes it's split evenly between the two, and then the court has to make a decision as to whether or not it's fair use. Fair use is incredibly, incredibly fact specific. There's no bright line. People want a bright line. They want a happy rule that they can follow and say, oh, if I just do this, it's going to be good. You can't say that. You can do an analysis and then you can decide. But you can't look at what your neighbor has done and assume that just because they did this, it's going to work for you, because there might be one fact that is just slightly different and could totally change the nature of the analysis. And this is the most frustrating piece, because people want easy rules, and that's understandable. But as long as you sit down and you say, okay, amongst all of this, okay, I think this is probably going to work in our favor, then you could go forth and say it's a fair use argument. And I say argument because it's not an excuse. Fair use is a defense against an infringement claim. Now, on your behalf, to your benefit, because what was happening was people were running out and willy-nilly yelling infringement, 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 and everyone had to defend themselves against that. And I think it scared a lot of people. The courts are now saying, no, you can't just willy-nilly bring an infringement claim plaintiff. You have to actually show the court you did a fair use analysis. And if it does not look like it's going to work in your favor, you cannot bring this case. So knock it off. And so they're putting the burden on the plaintiff to show they've actually done this analysis before they've, and if it doesn't have to be perfect, but if it's so obvious it's fair use, and yet they bring an infringement claim and they did not do the analysis, the court's going to slap them down. So you can step back and breathe a little bit after I've given you the lecture about how hard it is, because the courts have tried to balance out that issue. So people say to me, hey, you know what, under this new law, 76, why should I spend the money to register it with the Copyright Office? That's money I don't have. I got a teeny little budget. I understand that. It does provide statutory protections, though, if you own the copyright to something. First of all, it puts the burden on the other party that you don't own the copyright. Now think about that for a minute. It's a burden shifting. You have the presumption on the part of the court that that copyright belongs to your organization. And so someone coming along trying to argue it doesn't belong to them, now it's their burden. They have to pay their attorneys to prove otherwise. It's a burden shifting. Sometimes it can be really, really hard to show how much damage has been done on a monetary basis when copyright has been infringed. And the courts recognized that. And they said, look, we'll put in statutory amounts that you potentially could claim. So they said it can be up to $150,000 per willful infringement. This goes back to notice. You don't have to put notice on anything. But I highly recommend, if you have publications of your own that your organization is putting out, put a copyright notice on there, because then it becomes really, really hard for a third party to say, well, I didn't know this was protected by copyright. The notice is right there. Put it on your website, put it on any publication you do. And that makes it harder for them to argue that they didn't know, and it leans towards the willful. If you can show it was willful, you can reclaim all your attorney's fees. So that Tom Forsyth guy, he only had $22,000 in actual damages because, surprise, surprise, nobody was actually buying his photography, as nobody apparently wanted to put it on his wall, on their walls at home. So he really didn't have much in the way of damages, but he got millions of dollars of attorney's fees because of Mattel's malfeasance in pursuing this case. And a lot of that can add up to a ton of money because of the nature of litigation. So it's worth it to consider if you've got some really good publication. And now I'm talking more about your own publications that your organizations might put out. You might want to really consider whether or not it's worth it registering it with the Copyright Office for that very reason. And I've seen beautiful publications been put out by all sorts of organizations, and they don't register them with the Copyright Office. And I just hate for them to think someone coming along and copying those publications, and now you're stuck trying to fight this infringement claim when you don't really have a whole big budget to begin with. Final note, I'm going to talk about licensing, both on your behalf and whether or not you're licensing out stuff to other people. There are two types of licenses, and these are terms of art, and they're really important. An exclusive license. You own the copyright, but for practical purposes, you've given it away. I liken this to owning a car. You have title to the car. It is your car, but you give it to your college kid to take to college, and they drive off with your car. You still technically own the car. Not much you can do with it because you don't have it anymore. And that's when that's the equivalent of exclusive license. You technically own the copyright, but you've given the ability to do anything with it away. If you can't get a copyright outright from the owner, This is the next best thing in your deed of gift, is to get an exclusive license, because they might still technically own the copyright, but they basically give you permission to do whatever you want with it. You don't want to grant this to another person. So if you've got things that you've generated, publications you've generated, don't grant an exclusive license to people. You don't want to do that. Non-exclusive license maintains control of everything. It says, yes, I grant you the right to copy this, but I can grant everybody the right to copy this. It's not exclusive to you. These are very, very important terms to keep in mind when you're either licensing out your own work as an institution, or whether or not you're trying to get a collection as a gift. Creative Commons, this one comes up a lot. People think Creative Commons is copyright protection. It is not. It is merely an efficient platform for licensing a work. So if people, and more institutions are actually doing this, that they're putting either their work that they know, the collections that they know online, saying, we know this is in the public domain. Some organizations, if they have publications that would technically be protected by copyright, they'll put it up and say, you know what? We're just going to put this in the public domain. We're not going to claim copyright to this. Or they're going to say, yeah, we claim copyright, but we're going to allow people to use this for the following purposes. So you're seeing this more and more with various museums and institutions, where they're putting their collections up on Creative Commons so that people can research and say, or on their own website, if they've got their collections up on their website, they're using the Creative Commons designations. And one of the newest ones is actually CC0, which is the designation that they've given for something that's in the public domain. And that just makes research that much easier for people to know if something is in the public domain or not. For more information, here you go. United States Copyright Office, make sure you type it in correctly. You want copyright.gov. There are a lot of posers out there pretending to be the Copyright Office. And so you don't want to get stuck on one of those websites. The next one down is a great little handbook. It might be a little bit dated at this point, but it's a great little handbook for cultural institutions on copyright law. And it does cover the 1909 Act. I've given you the catalog of copyright entries, that database that also has those books, that if you needed to follow up on copyright, you could. This is my contact information. If anyone has any questions, I definitely highlight, say, feel free to reach out to me. I realize this was a lot of information to throw at you, and I'm already seeing a bunch of questions pop up in the Q&A. So if you come up with something at 3 o'clock in the morning, like we all do, feel free to email me, and I'm happy to answer. And as Darlene said, if you have questions that we don't get to, I'm more than happy to answer. And at this point, we will open it up to the Q&A.
Okay, Amanda, so we have a good amount of questions, as you saw. So I will just read off, and everybody can get their answers. So we're starting with, where do copyrights from another country, say England or Canada, fall into US law?
Okay, that's an excellent question. So the way that it now works, as of 1989, because we've joined the Berne Convention, as long as you are a signatory to the Berne Convention, of which Canada and the UK and Egypt, and there's quite a few countries that are, those copyrights are protected under US law, and vice versa. Those are protected. Under the old act, which got confusing, is that the only way they were protected from another country is if we had a specific treaty with that country. So eventually we did have treaties with US, the UK, Canada. What became very interesting is that we did not have treaties under the 1909 Act with, surprise, surprise, the Soviet Union. So what was happening there is works from particularly musical compositions, Prokofiev, Stravinsky, they'd come to the United States to be performed here, public domain in the United States, protected in the Soviet Union, public domain United States. We've tried to rectify that, but now we've made it a lot easier because we're signatories to the Berne Convention. If you want to know who's a signatory to the Berne Convention, Wikipedia. There's a list right there. And so it's a mutual agreement to protect each other's copyright laws. So you don't have to register your copyright in every country that you want to publish in.
So it just goes to show how confusing this whole thing
Yes.
really is. Yes. Okay. Hang on one second here, please. All right. If a library puts a transcription of a 1927 diary on a website for access, is that a violation of copyright law? What about a photo taken in 1980 that was donated, but not by the photographer?
Ah, photography. Yes, so that's a tricky one. So if it was someone, okay. If it was a studio who took the photograph, right? So say it's a college picture that was taken by or a wedding picture taken by a studio in 1980, it's highly likely the studio retained the copyright to that. The donor does not have copyright rights to that. If it was taken by an individual and the person donating it is the heir to that individual, then it's possible that the copyright has flown through, basically through estate planning, through the various testamentary documents. I actually have a whole separate presentation that talks about estate planning and how title passes, and I do talk about copyright in that one. So stay tuned, because photography in particular, letters in particular, get very, very tricky because the recipient of the letter only owns the letter. They don't own the intellectual property in the letter. The writer does. And photography can be very, very similar. So your very first question would have to be, was it taken by a studio or was it taken by an individual?
Mm-hmm.
Studio is likely to own it. Individual, it gets more complicated in terms of the relationship between the person donating it and the photographer.
And what about the first part of the question? If a library puts a transcription of a 1927 diary on a website for access, is that a violation of copyright law?
Yes, potentially. So I'm going to go back to my share screen real quick because I'm going to pull up my chart. Okay, so you're initially dealing with an unpublished work, right? So never been published. It goes into copyright. It goes in public domain 100 years later, or 120 years later, so 1900. However, if it was written in 1927, now you're talking about publishing. It's been published. So depends on when it was put up. Okay. So say it's after 1989 because it's on a website. So I'm going to assume it's after 1989. Been put up. So it's published after 1989, even though it was 1927. No formalities. What kicks in? Life of author plus 70 years. So you're going to make me do math, aren't you? All right, help me out, folks, if someone's faster than I am on this. If it was written in 1927 plus 70, if the author died in 1997, the minute you published it, and the author died in 1997, it went into the public domain. Are we having fun yet?
Okay.
On
On
a
a page,
author lived forever, like say that author wrote it as a child in 1927 and they lived a really long life, say 1927, they were 10 years old. Some kids write diaries and they lived to be 90. Okay, 2017 is when it went in. So yeah, you really have to think about that math.
yeah, that's quite an important thing. On a painting, can the copyright notice go on the back of the canvas or must it be on the front?
Ah, yes, that has been actually litigated in the courts. That's a really good question. It's kind of gone back and forth because on the one hand, the courts have said, no, it's on the back. So initially they said, no, it was on the back. People couldn't see that it has notice on it, but they flipped and they said, no, as long as it's on there somewhere, it has notice on it, because in theory, you could take the painting off the wall. And I know this goes against every instinct of the museum world, to no touching the artwork. But in theory, the argument was you could take the painting off the wall, you could turn it around, and you could see the copyright notice. So as long as it's on there somewhere, under the old act, the courts were okay with that.
Great. And what about a copy of a photograph? Can a copy be a photograph of the item?
Yes. Yes. Actually, this has also been litigated, because what people were trying to do was say, oh, this is about to go in the public domain. Let me take a picture of it, and then that'll extend the copyright. And the courts said, no, that does not extend the copyright of the underlying work. But you do have a nice little copyright in that new photograph you collected, you just took, but that's only limited to your photograph. The underlying work is still in the public domain. Now anyone could come along and take a photograph of it. So taking a photograph of a public domain work does not, or something that's about to go in the public domain, does not change that original piece's status.
Okay. What if an artist puts a copyright notice on the back of a canvas, or a photographer on the back side of their photograph? Would that fulfill their requirement?
Yes.
In the catalog of copyright entities, it looked like things are registered with a number. Does that number have to appear on an item or object in order for it to be protected?
No. It's merely a reference number back to the catalog at the Copyright Office.
How is due diligence defined when trying to find the owner of orphaned works?
Good question.
You knew that was coming.
Yeah. Oh, yeah. No, it's a really good question, because the courts have basically said they've taken into account the size and budget and staffing of your institution. So if you are a tiny little historical society with practically no budget, running on volunteers, as long as you've tried, you've shown that you have maybe looked at said, hey, it could be a memo to the file sort of thing, like, hey, look, we looked at the catalog of copyright entries, there's no notice on this, we have a name, but we can't find any more information about this person. They're going to treat that very differently than if you are at the Museum of Fine Arts in Boston. Because they're going to say, hey, look, you've got vastly different resources. We're going to expect a lot more from you, MFA Boston, than we're going to expect from this little historical society up in nowhere, New Hampshire. And I can make fun of New Hampshire because I live in New Hampshire. So, nowhere, New Hampshire. So they're going to take that very, very, as long as, and there is a range, obviously it depends on your resources. It depends on your budget, your staffing. They do not expect you to do a full genealogical research, with ancestry.com to try and track down who might possibly be the copyright owner. They just don't expect you to do that. And in fact, the client I was telling you about yesterday, that is exactly the problem, is that it was a husband and wife. They never had any kids. She died, donated the collection. And it was like, well, it's still technically under copyright, but they had no kids. They didn't transfer the copyright to the institution. So where is it? And it was sort of like, no, nobody's going to expect you to do a genealogical research, try and find these people who might be related to the people who might have originally owned this. So it is a spectrum with due diligence based on, your budget, your staffing, the size of your organization, etc.
So having no money does cut you a break in some instances.
In that case, it actually does.
If we take photos at one of our events, and it's a free event that captures people, attendees who are present, do we need to get permission from each person in an image, or remove that person before we can use it in print or on our website? This could include in-person events or taking screenshots of people attending one of our free Zoom meetings.
Yep. Okay. So Zoom is actually pretty straightforward because you can say flat out, we're recording you people, like you just did at the very beginning. So that makes Zoom actually makes it much easier. The events, that is an excellent question. Not quite copyright. You're dealing more with the idea of rights of privacy. Now, when it comes to events, if someone shows up at a free event, it's kind of anyone can take a picture of anybody at any time. If you're out in the public, that is fair game. Where it becomes a little bit more tricky is kids. Adults are free, basically free game. Kids are a lot more difficult. So I would definitely say if it comes to kids, you want the parents' permission, or try and keep the kids out, or maybe kind of get them in an angle where you can't really identify the child. Or what we used to do when we took pictures of events is we actually took the director and the assistant director's kids and staged it. So it's like, oh, look, these same kids keep showing up in all the photographs. That's kind of what happened. The other thing you can do in terms of live events is just put a sign up at your cash register box, or wherever tickets are being collected, or wherever people are coming in, and maybe just a spot here and there throughout the event saying, we're taking photographs of this, and you by being here are acknowledging that we could be taking your picture.
Yeah. And I would also take a picture of that little sign for your records.
Yeah, get that picture in there.
Yep. Because if somebody comes back, you can say, oh no, here's the sign.
Exactly.
If an archives has a photograph in their collection that's in the public domain, and a TV production company asks permission to use it in their upcoming TV show, does the archive still need to provide written permission to the production company? And can the archives charge a licensing fee for providing an image that's in the public domain?
Yes, to both.
To both.
For two reasons. One is the production company, depending on what they're doing, their people at the end are going to want to see they have permission to use everything, even if it's solidly in the public domain. And that's more to protect them than it is you. And I have several instances where that's the case, where we're running around trying to get licensing rights or permissions. So we just, because the publisher, the production company, the end user, the distributor is going to want to see that the permissions are all there. You can absolutely charge a fee. Depends on your, now this is where the tricky part comes in, because some people say, well, it's in the public domain. How come I have to pay a fee for it? Well, first and foremost, if you're the only one with that particular image, then you have a monopoly on it. And let's face it, to pull up that image, to get a good quality scan that's actually going to work for these for what they want to do, takes time. So you, I think, are perfectly justified in charging a fee to reproduce that image for them, even if it's in digital format for them to use. I think it's perfectly reasonable. And I think the more difficult the access in terms of you having to go, if it's something really rare that you're like, oh, we have to now go to our offsite storage, because all that lovely offsite storage that we all have. If you have to go to an offsite storage facility to go through the archives, to pull it up, the more effort it is on your behalf, obviously the higher fee you can charge. I don't have a set value. I think it really depends. The last one I've seen, it ranged anywhere from $300 to some real nasty pricing, and you have to balance what's of good value for us versus what's going to turn people away.
Right.
In terms of, wow, I'd really love to have my image used in this production, but if I charge too much, it might turn them away.
Right.
I've done exhibits where they wanted so much money for a public domain image that we ended up not using it.
Yeah. There is always that chance. Can we take photos of people in a public space and use them to illustrate a COVID-19 documentation project and also use them on our website?
I'm not quite sure the crux of that question. because we've already got the public event thing taken care of.
Mhm.
It's the context of COVID-19. I guess my interpretation of that question is you don't want to take a situation and then put it in a context of which. So in other words, you don't want to take an event and then make it look like it's a COVID-19 thing when it's not.
Mhm.
So maybe the person who asked the question could clarify a little bit better what they're thinking. Because I don't want to misinterpret that question, but I don't want to see a situation where you've had an event and then somehow you say like, oh, I don't, I'm not sure.
All right, let me see if I can find the gentleman. Okay. Okay, Washington Historical Society, could you clarify your question, please?
Yes, we have a project where we're working with the community and through ourselves to document the impact of COVID-19 on our community. So one of the things we've done was we went around town and took pictures of different signs people put up, like at the church, please wear your masks, and the town hall. Here's the things you have to do in order to safely enter the town hall. And we have a weekly farmers market, and people had to wear masks and things to go to the farmers market. So it just shows people at the farmers market wearing masks, basically. So in
Oh,
other
okay.
words, it's the impact of what, on our community of change to everyday life.
Yeah, no, okay, that clarifies it a great deal. Yeah, absolutely. You're doing a documentary thing. You're taking the pictures of, the various signs. I think the potential issue in that case is that you want to make sure you're just documenting this and that, because you're treading into trademark law because you're taking pictures of businesses and the church, and you just want to make sure you're clear that they aren't actually endorsing the project. They're not part of that you're purely documenting this on the part of the community. But certainly the farmers market, I guess my biggest concern with the COVID thing was putting people in a negative light, because people are kind of touchy about that. But that doesn't sound like what's happening here. You're literally going through and you're documenting this is what's happening. And you can see everybody at this farmer's market wearing masks, whereas look at the pictures from last year, it's a very different scene. And that's okay. I don't think you'd have too much trouble with that.
Okay, thank you.
And from the same participant today, he has a question for the diary question. If the person died in 1997, then isn't it 1997 plus 70?
Oh, that's good. Life of author plus 70, you're right. Thank you. See, this is why I need help with my math. So you're right, if it was 1997, so yep, 1997 they died plus 70. Yeah, 20, and it would be 2067. It would go into the public domain. So yeah, if you publish that diary and that transcript now, it would technically still be protected by copyright. So the question then becomes, did you get the copyright permission? Is it an orphan work? So it was a 1927 diary that was transcribed and put up on the website. Yeah, I think and depends on the other thing too is when did the diary come to the Historical Society? Yep, Tess is right. They'd have to have died by 1950 in order for it to be in the public domain today. So I guess the other piece is, when did it come to the Historical Society? Because if it came to the Historical Society before 78, copyright followed. If it came after 78, copyright did not follow.
Okay. I see that we are a little bit after 3:30, so why don't we take a few more questions so that everyone can keep on their schedules, and then we will address the answers to these and circulate them after the event. Did I understand correctly that for original works donated before 1978, we own the copyright?
Correct.
Perfect.
Copyright followed unless there was a writing stating otherwise. So in
Okay.
other words, the person donating the collection had to explicitly state in writing, I'm keeping the copyright.
Okay.
After 78, flipped 180.
And we'll take one more and then I think we'll wrap it up because I do want to make a couple of comments with respect to next week's event. So the last question we'll take for this afternoon is, could you talk about what constitutes transformative use?
Okay, that's been a huge area of discussion because especially you've got modern day artists who are really pushing the boundaries of what is considered transformative. The most recent was, and I can't remember his name off the top of my head, but he was taking pictures off of Instagram and blowing them up and adding a comment, and he was trying to argue that that was transformative. And I think a lot of us in the legal profession were like, really? That's really not particularly transformative. There seems to be some pushback from the courts as to what constitutes transformative. There is a case out there. It's the Dr. Zeus estate versus Comic Mix, COMICMIX, Comic Mix. And or just look up Dr. Zeus parody mashup. You'll find it. It's a book that was basically taking Dr. Zeus styled characters. Richard Prince, thank you, the one with the Instagram, Richard Prince. Basically what they did was they took Dr. Zeus styled characters and put them in a Star Trek universe. So, and then they titled the book, All the Places You'll Boldly Go. And that has been going back and forth. The original lower court ruling said this was fair use because it was transformative. The appeals court said, no, it's not transformative just because you took these characters and put them in a Star Trek universe. ... To be continued. We don't have a really good answer on that. But the more you pull it away from its original, the more sort of transformative it becomes. So think about the Barbie case. They said that was definitely transformative. If you took Barbie and just maybe changed her hair to purple, they might say, no, that's not necessarily transformative.
Okay, excellent. All right, so Amanda, thank you ever so much for this afternoon's
Oh, you're welcome.
conversation here. It looks like many people got a few questions answered and feel better about copyright, but still with lots of, I'm not quite sure. So to our audience, thank you for joining us, and we will get the rest of these questions answered for you and circulate. A couple of things I'd like to mention again. If you haven't already, please subscribe to our mailing list so that you can get advance notice of our events. Consider becoming a member. Check out our website, look for our membership link, and see if you qualify for one of the 3 membership levels, or join us and become a friend. Look for the link to this recording to be sent to you. You will also get an email with the survey that we'd love for you to fill out and complete for us. And the third thing I'd like to mention is the conversation with colleagues, which I had mentioned in my own introductory remarks. With this particular workshop, we will allow all registrants in. It's typically a member-only event. And that event, you will get a link for it. That event is next Thursday, March 25 at 12 noon, same place, same channel. Amanda will be joining us, and we'll have more of a conversation between colleagues about copyright, and any further questions that come up, we can answer at that time. So I think that is all I needed to say. Again, we thank you so much. Amanda, again, thank you for joining us today, and we look forward to seeing you next week. And Eileen, any last minute words from our hostess?
Unmute myself. No, thanks to everyone. Thanks to Amanda and Darlene, and it's been wonderful. We look forward to seeing you again next week. And again, the recording for this will also be out to folks, hopefully. The one quick question in the chat that I just wanted to do before we went, there's a question about if we could share your copyright chart Excel with other people, if that's okay.
Well, guess what? It is purely factual information. So absolutely.
Spread the word. Spread the word. And make sure you give her credit for having put it together, right?
Yes, I was going to say that's the next thing, copyright, but what credit is
Totally
Even if it's not
different.
copyright.
Yes.
Right, right. But at least they know where it came from. Right.
Wonderful.
Okay, everyone. Thank you so
Yeah.
much for joining us, and we look forward to seeing you next week. Bye.
Bye.